first thing in our good news recap for the week from the front of the legal battle to save the soul of our democracy. And boy, do I it's not even a decision exactly. So I think you remember, for those of you, for a quick refresher, when a case is appealed to the Supreme Court, that process is called an application for a writ of certiorari. That's a mouthful, so lawyers just call that a writ of cert. And all that means is, hey, Supreme Court, we have a dispute here and we would like you to review the case. Will you review the case? The application for a writ of cert is nothing more than one of the parties asking the Supreme Court to look at the case. And then the Supreme Court will either accept it, or they will deny certiorari or deny cert. And all a denial of cert means is that the Supreme Court has decided that they don't want to even look at the case. So, in fact, it is extremely likely in many of these cases, applications, that the Supreme Court barely reviewed the case. They're not going to get into the weeds on something that they already know they're not going to give their time to. And that's another way of thinking about the application for cert. It's like, hey, Supreme Court, would you take some time to look at this case? And when cert is denied, it's the Supreme Court saying, nah, we're not even going to look at the case. It is not at all a commentary, let alone a decision on what is in the case and the merits of the case. So that's really important to remember always. But this past week, or this week, the Supreme Court denied cert to Trump, who was appealing the E. Jean Carroll case. So I love that for him. So again, it's not a decision, but the Trump said, hey, people keep calling it Trump's Supreme Court. So like, hey, my Supreme Court, my buddies there in the Supreme Court, please take some time to review this case against this woman that I was accused of sexually abusing, and now I had to pay her a whole lot of money, and I want you to review that. And the Supreme Court said no. And I love that for him. And also, you should know that Trump has already paid her. He did pay that penalty with interest. So that is essentially the end of it, at least for this legal line. And as usual, what I will do at the end is look at the chat to make sure there is nothing about that particular piece before I move on. So Chris is saying that they thought that it was the second time the court refused to rule in his favor on the case. So, I mean, this was a different challenge. And again, it's not refusing to rule in anyone's favor. It's refusing to rule at all. They don't want any part of it. Okay. Next. And, it would be very helpful to me for those of you in the audience, both Notes from the Front members who got the actual documents, but also everyone else who got the posts about these. If you have comments about, if you actually read my post or read the documents, then, that would be helpful if you would let me know that, because that will tell me if you are, remembering it, or do I need to, explain it in more depth here. So in any event, the next thing that happened this week is that the court absolutely slammed another misappointment, in other words, wrongful appointment of an assistant U.S. attorney. And that meant that all of the attorneys' cases, were now basically on hold, because the attorney, a quote unquote attorney, well, there are attorneys working on the case, was wrongfully appointed by the DOJ, and so therefore they cannot work on those cases. So you will remember some time ago that this happened with Alina Habba, right, in New Jersey. And there were several defendants in several cases who got together and filed a lawsuit basically saying Alina Habba was wrongfully appointed. She's not actually qualified procedurally to be an assistant U.S. attorney, and so she was removed. And while they did it again, this time it was in Nevada, and but a nearly identical fact pattern, but not quite. So in this case, and I'm not sure how to pronounce this attorney's name. I think it's Sigal Chattah. Uh, the same thing happened, that in as much as the DOJ misappointed Chattah and then had Chattah go and, file all these criminal lawsuits against these defendants. But this time, they didn't do it the exact same way they did it with Habba. They tried a different tact. And so bear with me while I explain the procedure. An acting U.S. attorney, we talked earlier about support staff, right? An acting U.S. attorney has an assistant attorney who is called the first assistant. So if the acting U.S. attorney, for some reason, leaves their position, whether, they're reappointed or they quit or they're fired or, they get nominated to be a judge, whatever the case may be, if an acting U.S. attorney leaves their position, leaving a vacancy, then the first assistant steps into that position until the position can be filled. So are you all with me so far? Okay. So the administration attempted to Sigal Chattah was the first assistant. Or no, I'm sorry. Sigal Chattah was just a U.S. attorney, and then the DOJ appointed him as the first assistant. The thing is, there was no assistant U.S. attorney in the position to which they attempted to make him to be the first assistant. In other words, the administration bumped him up to be the first assistant to nobody, to a vacant